No! Continue this hearing, sir.
Why?
You're not going to give me a fair trial. You cannot let... There's no context to an act that took place outside of 1 year. It's prejudicial to my case. It's hearsay at this point, and it's irrelevant.
Hearsay is admissible in one of these proceedings.
She's not admitting hearsay in an injunction harassment for an... There's no legal standard to talk about something that happened outside the 1 year period in an injunction for harassment, sir. We can turn this into a kangaroo show, or you can enforce the rules like every other judge in this county. You cannot talk about something for context. So I get to talk about anything I want then, for context. I get to talk about how I think she got my wife fired for calling Judge Zips. Context, right? It's context, right? No, it's fucking irrelevant. It doesn't matter if I contacted her 100 times before then. Thank you, I won't cuss again, but you can't just allow this thing to spiral out of control. There's rules to this stuff, man.
Now, well, why don't you try to evade something?
Who's gonna hold you in check?
Well, I guess you can appeal.
That's all you care about, right? Oh, I guess you can appeal. My rights don't matter to you?
Yes, they do. Go ahead.
There is no grounds, no legal grounds for you to issue a continuance halfway through the hearing because the plaintiff didn't get her way. That is absolutely not what happens in these hearings at any point in any time, and it will not happen to Lane Myers.
911, what's your emergency?
No! You gotta be...
So Lane is back. It's related to an injunction for harassment, and it's against this woman.
Her name is Stacy Jane. She's a professor in the law department at the University of Arizona. She's also a bar card carrying lawyer.
Now, listen as Lane ties this to the other cases he's involved in. And like in the other hearings, this isn't going to go well for Stacy.
Make sure you watch this all the way till the end, because just like in Lane's other videos, it only gets better.
There's no objections allowed under 122H, sir.
What is the purpose of the recording? Did you say this is your own personal recording for your own person?
Personal audio device. Kept on or near the person.
Anybody can make an objection.
I get what you're saying, though, but like, I've been going through this at every hearing I go to. Let's move on with the hearing.
No, let's talk about it first. What are rules required here? Just tell me what your position is.
On what?
On whether or not I should permit the recording person.
You don't have authority to stop me. It's a Supreme Court rule.
If you've seen Lane's other hearings, they all start off the same, arguing about recording. And he always wins the argument. Watch.
The presiding judge has already given me a court order that says I can do it. So what do you want to do here?
You want to hand me a copy of that?
Yeah, it's called Administrative Order 50-4.
Okay. Well, let me see yours.
You look at it's signed by your presiding judge. You're required to follow the rules, not me.
I am. I'm going to follow the rules.
All right, good then. So let's move on.
Don't tell me how they run the courtroom, sir.
There's multiple people in here that are going to be recording, and you're not going to stop us.
I'm not?
No.
Your Honor, I would object to any recording in the courtroom.
She doesn't have the authority under 122H. We're not going to divulge this. This is a waste of both of our time. You can continue if you want to debate this. Continue the hearing.
All right. We will continue your hearing for a separate hearing on purposes of 122.
To what?
For hearing on.
Yeah, because I'm going to file an injunction against you.
Okay.
To enforce 122H at Superior Court. I'm going to go get an injunction right now.
Do you have a copy of the rule that you would like?
Do you have a copy of 122?
I can get a copy of the rule.
Pull up 122H. You guys got a copy of it? Here, I'll pull it up. Can I pull it up on my phone and show it to you?
Sure.
Okay.
I mean,
I've been going over this in every court in the past 3 months, and I've come out successfully every time. And any judge that tried to stop me got hit with a special action. So
No, you can hit me with a special action.
it's an administrative thing. You do not have judicial immunity for administrative decisions, and these rules fall under judicial.
I'm asking you just.
I'm gonna show it to you right now.
Okay.
50-4, or excuse me, 122H. 122H. I cannot believe you're letting this hearing start into this. You're biasing the jury. You're the jury, sir, and the judge. Right now, you don't have 122H hearings before a matter. Now this is prejudicial against me, sir, because you and I are having an adversarial conversation before my hearing where you need to decide on my credibility and my, whether I'm...
You're going to show it to me or not?
Yeah, I am.
All right, that would be sufficient for you.
Because I just had a Superior Court judge go over this.
Okay,
I'm not...
fine.
You're prejudicing my case right now. You're prejudicing them. It's literally on your own website.
I'm sure it is. I don't have it present in front of me, so.
That's why I gave notice ahead of time.
I just got the notice like 30 seconds ago.
Because that's all I need to do is
Okay.
tell you when I walk in.
I'm sure that's fine. I just, as a favor, I'm asking you. So
I'm showing it here right now. Here you go. 122. There you go. H. Go to H.
Right?
H.
Why are you video?
Yeah, why?
Hey, why is this guy video recording? You get what I'm
No
saying?
cameras yet.
No, look, sir.
I just said.
No, but there'll never be video recording.
Video, they allowed.
Video, you do have to put in a notice ahead of time. My bad.
It's true, I just told him to stop.
Okay, but no, he should be held in contempt and removed from the hearing. He just said, "Fuck you, punk," to these people. Get an officer in here, sir.
That's aggressive.
Hey,
This is
the
my.
rest of you, I allow
This
you
is
to-
my party. This is my family.
That's great that your family.
So why is this guy using cuss words at my family in the gallery?
I have no
Why is he
idea.
filming?
Do you want to have the hearing or not?
I do.
Why is he still sitting in here?
Why hasn't this man been removed when he's in violation? Sir, if you want to video record, you have to put a notice in ahead of time. We're not trying to video record. This man just pulled his phone out when there's signs all over the building when you walk in that say no video recording allowed. This man just pulled his camera out in this court and pointed it at us and recorded you at the bench right here without a notice, and then he said fuck you to these people and you haven't kicked them out yet.
Because I haven't had a hearing or know anything about it other than what you're telling me.
You just watched him.
Okay, are you going to listen or are you going to participate?
Absolutely, sir. This is.
Have a seat.
Thank you. You got my phone. Are we
I
gonna
do
go?
have your phone, I'll give it back to you, but you haven't given me an opportunity.
Is
to
it
look
still
at
open?
And the rest of you folks.
Is it still?
It's still.
It's still open.
I don't
122H personal audio recording. No video, sir. We agree. No video.
I agree.
Nobody's trying to
Okay,
do video.
I'm trying to read.
Except him right there, and we need a copy of that video. You need to order him to give me a copy of that video or delete it in front of you. This is how it works in here. We've been dealing with this for many years with Judge Klotz and Judge Riojas. You cannot film video in here. That's a crime.
Okay.
He should be arrested. Just like we get arrested if we video in here.
I'm happy to delete it.
Just deleting it.
Oh, look how easy he's just, hey, sir, can we video? This guy, man, is videoing in the courtroom.
Let's not video on court, okay? I just deleted it. I didn't know, you were, I thought.
There's
you were
signs
saying that.
everywhere.
Okay.
Did you
Hey,
get out of the-
Mr. Meyer, you guys.
I
You
know.
would have been kicked out.
We would have already
You
been,
would have been kicked out.
permission, bro, I'm not.
No.
Hey, we would have already been out though for it.
Okay, that's fine.
We want to follow the rules.
Sir, you're going to be removed if you do not remain quiet. Don't tell me what to do.
Please, sir, can we just all calm down and cooler heads prevail and all of us be grown-ups in
It would
here?
help if you let me read
Thank
the
you. You
roll.
guys, let's all just be grown-ups for a minute.
You're not allowed to record in this matter.
I understand. I deleted it. I deleted it off the recently deleted. I'm happy to show you.
And did
my
you use any profanity with those folks?
What's that?
Did you use any profanity towards any of those people?
I did.
And why was that?
Because I felt like I was being harassed. They were telling me what to do.
We were showing you the rules, or telling you.
Hey, did I ask you to talk?
No, Your Honor.
Okay. You made it,
And there was
you made
already
it permission to
swearing
talk
going
about
on that side. There was
Nobody
already-
not one person swore over here.
Which,
Not one person used profanity. He did.
sir, allow me to at least control my court.
Thank you, sir. I appreciate it.
I was actually talking to a person about the concerns you expressed.
Thank you.
And you keep on constantly interrupting me while I'm trying to do that. And I don't know what is the purpose of that. One, you are not allowed to video, you now know that. Two, you're on warning that any further disruptions. I understand you have concerns with what other folks may say, and we'll pay attention to that. But you yourself, any further adverse actions in your could result in your removal from the courtroom, okay?
I understand.
And can I get the 122?
Is it still up the screen?
Yeah, it's still
Oh, yeah,
up.
okay. Thank you.
I read 122H. Are you familiar with 122H?
I am not.
Personal
I
recording.
would
It
like
does
to
permit the
respond.
use of a personal audio recording.
So I point you to Arizona Rules of Protective Order Procedure 8A2, which requires a judge to ensure that the parties are treated with fairness, respect, and dignity and are free from intimidation, harassment, or abuse during the court process. In addition, Arizona Rule of Protective Order 38E says that the court must take reasonable measures to ensure the parties and any witnesses of the hearing are not subject to harassment or intimidation in the courthouse or on adjoining property. Mr. Meyer's house live streamed previous court recordings and posted videos about me and discussing me on his YouTube channel.
Objection, Your Honor, that's not relevant to the complaint. She's going outside the bounds of the complaint. She's talking to things that are not in the petition. This is not a protective order. This is an injunction for harassment. Those rules do not apply. 122H applies. I was just at an injunction for harassment hearing at...
Sir, would you let me listen to her first, and then we'll be allowed the opportunity to speak?
The videos posted by Mr. Myers have also prompted other videos on YouTube about me.
Sir, she's litigating the case. She's litigating the case right now, sir. You cannot allow yourself to be prejudiced by you. This shouldn't even be happening right now. This argument about 122H shouldn't even be happening. And you're allowing her to make arguments about a protective order, and she's pulling out legal jargon that is not applicable here. And she's talking about videos that are not in the petition. They're not in the petition. She's prejudicing my fair trial right now, and you're allowing it. This is all on the record for appeal. The transcript will show you're allowing her to talk about a protective order at an injunction for harassment hearing. Follow the rules. This is a civil procedure. It's not a protective order.
I'm not finished.
It is a civil procedure. It is a protective order.
It's not a protective order.
It's not a...
It's ARS 13.
Yeah, I call protective.
Come on, man.
Arizona Supreme Court Rule 122D says that the judge can deny a request to record or live stream a proceeding.
A request from C.
If the recording will negatively impact the party's right to privacy, safety, or well-being, or based on any other factor affecting the administration of justice. And Arizona Supreme Court Rule 122.1E says the judge can deny the use of a portable electronic device in the courthouse if use of that device is contrary to the administration of justice. And for those reasons, Your Honor, I respectfully request that both Lane Myers and other participants in the courtroom today not be permitted to audio or video record this proceeding, particularly because it will end up on YouTube and I will receive.
I'll tell you what, we'll turn our recordings off if you turn the court recording off, because it'll go on YouTube whether it's I order it for $17 and have it by the end of the day or not.
Would you allow me to? Thank you. I believe Mr. Myers is correct in regards to 122 in regards to personal audio recordings. Obviously, no video recordings are allowed. Everybody got that? This matter is in fact audio recorded by the court. You're allowed to personally audio record it yourself. If you do so in a disruptive manner, that will be a separate issue, but for the moment, we'll assume that we're going to abide by that rule.
Thank you, sir. Yes, thank you. Can we please get back to...
Could you please quit telling me what to do? I'm allowing the way you speak, what you speak.
You allowed her to prejudice you, but go ahead.
Okay, would you quit? Is there anything you want to state in advance?
I would like, if possible, to start the hearing discussing the parameters of the issues before the court and the objections I plan to make.
You'll get a couple minutes and then you'll get a couple minutes.
I thought we start this by she needs to be sworn under oath.
Well, she's not testifying yet.
That's what she's about to do, testify. Any word she makes moving forward from the next moment need to be under oath. You don't get no free statements in a court hearing.
This is one of the multiple times Lane has to remind the judge how the hearing is supposed to go. Lane being the only person at this hearing without a bar card.
Put her under oath and let her...
I swear if her testimony will be the whole truth and nothing but
Who?
the truth.
I'm not under oath yet. You said it starts with her. The burden's on the plaintiff. Start there.
Yeah, sure. Her written testimony will be the whole truth and nothing but the truth. Did you have an opening statement?
Your Honor, my understanding of today's hearing is the issue before the court is whether Mr. Myers' conduct amounts to harassment under AS 12-1809, defined as a
Can I
series
stop
of...
for a second? Let's talk about something else. There's a second case involving you. Is that right, Mr. Myers?
With who? Today?
Yeah.
Yeah.
That has nothing to do with this case, right?
No, these are completely separate. The reason they put that today is because I'd already be here and we can...
No, I understand.
Right.
Are you here on the second case?
Yeah.
I'm gathering it's possible we may not get to that. We'll see. See how long this goes. Well, Mr. Myers, you seem to be wanting to take some time, so.
Take some time. I want to get through this kangaroo nonsense as fast as possible. I have things to do that are really important.
Well, then perhaps you can.
We just spent 15 minutes arguing about a circus. We just turned your court into a circus. She just turned this into a circus. I don't even feel like I can get a fair hearing today. Her person back here, we're here complaining about the person she brought with her has the audacity to start the hearing out by cussing out my family and video recording. This whole thing is about First Amendment and video. So put her under oath, and she needs to testify to what's on the petition and nothing else.
She's under oath.
Okay, because you let her make protective order statements talking about things that are not on this petition.
Okay,
and if you want to talk about things that are on this petition, you got to give me a chance to either adjourn the hearing or take time to go over her new statement. She needs to amend the complaint if she wants to talk about things that are on the not in this petition. And you just allowed her, under the protective order thing, to make allegations that are not in this petition, and you did not strike them from the record.
Okay, thank you. Go ahead.
I believe that harassment is defined as a series of acts over any period of time directed at a specific person that would cause a reasonable person to be seriously alarmed, annoyed, or harassed. The conduct, in fact, seriously alarms, annoys, harasses, and serves no legitimate purpose. I do plan to object at any point if Mr. Lane begins to testify to matters outside, whether the issue for the court, whether his conduct amounts to harassment. I'd also like to ask that not only that the protective order be enforced, but that it also prohibit Mr. Myers in the future from having any direct or indirect contact with me in the form of social media, that he be prohibited from posting or putting my contact information, including my work contact information.
She's an employee of the state, sir. You cannot allow this.
And that he not, through social media or otherwise directly or indirectly, encourage third parties to contact me or go to protected locations.
I can guarantee you that I'm going to keep those videos up and make more. And there's nothing you or her will do about it. She's an employee of the state of Arizona.
She's making a statement.
Is she done? Is that because she hasn't testified to anything in this petition or presented evidence of these allegations of harassment?
Did you understand that? Did you have no opening statement?
We have to get through this. Her opening. I just went through this last week. She needs to give her opening statement, and we need to enter the evidence in.
You have an opening statement.
As soon as she enters her evidence in.
Okay, you're reserving your right.
Sir, she needs to.
Don't tell me how to run the court.
I've been through these.
Good, I'm glad you have. I'm just asking, are you waiving your right to give an opening statement, or are you reserving it till later?
No, I'm gonna give it right now.
Okay.
Put me under oath.
Well, okay. You swear affirm any testimony you give the whole truth and the truth?
Yes, sir. Under the penalty of perjury. Make sure you say that to the next witness, or the next case too.
That's okay.
It is under the penalty of perjury, right?
Well, there are laws concerning perjury.
All right, because that oath means something, right?
It does.
Okay. So she claimed no legitimate purpose. Okay, she is an employee of the state. Second of all, there was clearly a legitimate purpose. First, so when are we going to discuss this? Because my opening statement shouldn't be about what's in the petition.
Okay, you want me to have her testify?
Well, that's what I'm saying is like my opening statement is going to be, are we just here to saying I'm here to contest this? Because I'm here to contest this because, first of all, there was,
That's what it is.
she put an incident on here that was from 2.5 years ago. So automatically, and this woman, let's make some judicial notice of adjudicative facts. She's an attorney, an Arizona member of the bar, and was a law clerk for 13 years at the federal court. She knows how to read a legal document, and where it says no items outside of 1 year, she put something for 2.5 years to taint, prejudice this, okay? Why would somebody with a law degree who spent a career reading legal documents put something that wasn't allowed to be put on this document if it wasn't willfully and knowingly an attempt to prejudice the person getting this hearing? You cannot put something, it's all within 1 year. 2.5 years ago, an email where she said thank you and have a nice day at the end of it. First of all, I had a legitimate purpose to contact her, and we're going to hammer that home today.
Are you testifying or are you making an opening statement?
Both. I'm making my opening statement.
Okay.
Because I'm here to contest this under LaFaro, Cahill and LaFaro and all this. First of all, she needs to prove 2 or more contacts within a year. So putting something 2.5 years ago, that's already written off. Okay. So then the next one you need to prove. She even stated herself, legitimate purpose. She's an employee of the state of Arizona, and the electronic harassment makes it very clear, which subsection C states, constitutionally protected speech or activity or to any other activity authorized by law. So if she's if she's a state employee, I have a legitimate reason to call her and redress grievances. However, I have a legitimate purpose beyond just the default redress grievances with a public employee. I called her asking her specifically a question about her she started this program, Access to Justice, right? So I have some legal matters taking place in the county, and I called her up and asked her if she had any help for me about at the instituted whatever Innovations for Justice or Justice for Steps to Justice or whatever these programs that she creates to make it seem like she is helping people in the community, where I call up there and I say, hey, Stacy, I mean, so are we I feel like she should need to testify before we, so my opening statement is, I believe these were, first point of order, she put something on there that wasn't allowed to be on there, willfully, knowingly, and intentionally in an attempt to prejudice this. Second of all, the two legitimate two contacts on there that we can talk about on the petition that were within a 1 year time period, I believe are legitimate whether she was a state employee or not. So let's let her let's let her testify to these contacts, and then I'll dispute them.
Why don't we do that?
Can I ask a question for clarification?
Sure.
Is the burden on me to justify the protective order should remain in place?
Absolutely.
Or is the burden on
The burden of
Mr.
proof is on
Myers?
you.
That is the law professor and lawyer not realizing the burden of proof was on her in this case. If I was her, I would be very worried right now.
It's on you.
Absolutely. You need to prove these allegations
I can answer that question.
beyond a reasonable doubt.
No, it's not.
Oh, if she doesn't want to get hit with a lawsuit, she's going to have to prove them beyond a reasonable doubt.
Well, that's irrelevant.
Abuse of process, malicious prosecution, all that. Yes, she's a lawyer and doesn't even know the burden of proof's on her. She probably didn't think this through very well.
Do you really need to make that comment?
This is deep.
I guess it is.
I guess we're not allowed to talk about what this all involves, though, because she doesn't want to talk about what happened and why I called her. But we're going to talk about it now, so I don't know how she can avoid it.
Oh, she can avoid it if you won't let me ask her.
Okay.
Okay. Burden of proof is on you.
Your Honor, I don't consider Mr. Lane's communication to me on December 2022.
2022, Your Honor, 1 year.
Okay, you can object to it. I'm going to hear from her first.
That's you cannot allow her to make statements that are not within the 1 year period. You can't. We don't have time. You're talking about we might not have the next hearing. You can't let her babble on about things that are irrelevant. And I don't need to be sitting here interrupting you. If it isn't in 1 year. This petition was signed on 10 what is because it's kind of scribbled 10/9, 10/7. What is the date? 10. The hand.
What's the relevance?
It was on 10.
Sir, I'm addressing your issue, sir. What is the relevance of it? What is outside that?
I am trying to move through my contact.
10/7.
Mr. Myers.
You don't get to talk about contacts that are not within 1 year. 10/7. Run this.
I have your objection. Objection overruled.
I'm
Go ahead
trying-
just briefly for context.
Trying to outline.
For context, no. Continue this hearing, sir.
Why?
You're not going to give me a fair trial. You cannot there's no context to an act that took place outside of 1 year. It's prejudicial to my case. It's hearsay at this point, and it's irrelevant.
Hearsay is admissible in one of these proceedings.
She's not admitting hearsay in an injunction harassment for there's no legal standard to talk about something that happened outside the 1 year period in an injunction for harassment, sir. We can turn this into a kangaroo show, or you can enforce the rules like every other judge in this county. You cannot talk about something for context. So I get to talk about anything I want then. For context. I get to talk about how I think she got my wife fired for calling Judge Zips. Context, right? It's context, right? My wife was the law clerk for a federal judge until I called her.
Have a seat. Briefly tell me what's the
You
relevance.
cannot talk about something about...
I can ask her what the relevance is, and you made a relevance objection, I get to have, she gets to argue it.
What I was trying to say before Mr. Myers interrupted me is that I don't consider the December 2022 contact to be harassment. It was included in the petition simply for purposes of identifying that the September 12th communication I received from Mr. Myers was not my first communication.
Okay, is that okay, Mr. Myers?
No!
All right.
It's fucking irrelevant. It doesn't matter if I contacted her 100 times before then.
Watch your language.
Thank you. I won't cuss again, but you can't just allow this thing to spiral out of control. There's rules to this stuff, man.
Now, well, why don't you try to evade something?
Who's going to hold you in check?
Well, I guess you can appeal. You can special-
That's all you care about, right? Oh, I guess you can appeal. My rights don't matter to you?
Yes, they do. Go ahead. That's fine.
My first communication within 2024 from Mr. Myers occurred on September 12th when he called my cell phone to say he had an access to justice problem. I don't have anything to add beyond what's already in the petition with respect to that communication. On October 2nd.
Well, hold on for a second. Are you saying that what's in the petition, what's the deal with that?
September 12th, 2024.
She's saying that she agrees I called there for a legitimate purpose, access to justice. She just testified that my purpose was
Are you
legitimate.
testifying now?
No, she did.
Okay, she's testifying. You
All
are
right. All right, go ahead.
not. No, thank you. I did give your permission.
I'm trying to be cool, man.
I appreciate that. Go ahead. So I'm just going to ask you, are you staying under oath for this time with that statement from November 12th petition would happen?
Yes.
I have the recording, too, with me.
All right.
And I'm going to enter it as evidence.
Mr. Myers did record that September 12th communication. without my knowledge or permission.
One party state.
You'll get the opportunity, you don't have to interrupt the counsel.
All right, I appreciate it.
Go
So
ahead.
just let her write this down, wait, let her go, and then come back after?
Yes.
Okay, go ahead then.
On October 2nd, 2024, Mr. Myers live streamed.
That's not on the petition, Your Honor. There's the 2 dates on the petition are September 12th and October 4th. There's nothing about a live stream on October 2nd on this petition. This woman is not capable of following rules, it appears. And she's an attorney with the Arizona Bar Association.
Your Honor, Mr. Myers has now made multiple disparaging comments about me during this hearing and.
Saying she's a member of the bar?
Okay, so let her testify, sir. Would you please do that?
Can you please let this woman follow the rules?
She can tell me of her contacts with you.
She cannot talk about anything that's not in this petition unless she wants to amend the petition and add the new events. Okay, I have the whole rule right here. She just said on October 2nd, sir, all right, I won't yell. Look at it. All right. But don't you have a copy of this in front of
I
you?
haven't, I'm asking her about it.
So why is she talking about something other than September 12th and or October 4th? She's attempting to prejudice this case.
If you want to move this right after she's finished.
Thank you,
testifying,
thank you.
You can do that.
Thank you.
Please do not interrupt what testimony.
All right, sir, I get
don't listen to
it.
motions.
I get it. Thank
Go
you.
ahead.
Your Honor, Mr. Myers' harassment has become increasingly worse since I filed and received the protection order petition, so.
That's nothing to do with the petition.
Contacts
Oh,
are,
don't interrupt her.
Jesus Christ.
I believe those additional contacts are relevant to.
Then
the
amend.
current protection order.
He is actually right, that if you're going to raise additional issues.
Can I move to amend the protection order petition to include additional harassing?
You have to do that ahead of time.
You wish to do that?
I move to amend the petition to include additional harassing contacts and to request expanded scope of the protective order.
Okay, I think you're gonna have to file an amendment.
Okay.
And then we'll.
So why did she bring us here? This is what I'm.
Sir! Just try to restrain yourself for a moment. You're the one who's asking for the amendment. You do need to ask for the amendment. If you want to ask for additional relief and ask for, include additional acts, then he is in fact entitled to have notice of that and to respond accordingly. So you need to go through. She has a form that you can fill out. We will continue this hearing.
You can't continue without hearing these incidents here. We're here. She can file an amended complaint after this. You can't stop the hearing in the middle of it and amend it. You can't. She needed to. This is all in the court rules. If you want to file an amendment, you need to do it ahead of time. Not come to the. You cannot do it halfway through the hearing. This is illegal. This is a tactic. She cannot do that. You have to hear this out. This is my day to be heard. This has already been continued once. In the interest of justice, I have the opportunity to be heard on these matters, and you cannot keep continuing them. Once the hearing starts, the rules are clear.
Watch as the judge completely changes his tune after hearing Lane's argument.
Once the hearing starts, there's no continuing. That's why it had to get continued before the hearing last week. Once the hearing starts, there's no continuing. So we need to continue with this hearing. She was not prepared. That is not something the court can save her from. You're not her attorney, sir. You're the referee. She needs to testify to these statements under oath, and you need to see if these petition, the matters that are directly on the petition constitute an injunction for harassment, and you need to either uphold it, modify it, or dismiss it today, right now. There is no grounds, no legal grounds for you to issue a continuance halfway through the hearing because the plaintiff didn't get her way. That is absolutely not what happens in these hearings at any point in any time, and it will not happen to Lane Myers.
Thank you. You wish to accept, Mr. Chairman?
If it's appropriate, I'm happy to testify to the content of the existing petition. And
Okay,
move to-
we'll proceed that way. I believe he may be correct in terms of the amendment issue. Go ahead.
So on September 12th, he called my cell phone, began explaining he was being criminally prosecuted for disrupting the city council meeting, said that I am.
She already talked about September 12th. We were moving it. She started September. She just testified 2 minutes ago, sir, that September 12th, access to justice, go with what's on the paper. Then she started to talk about October 2nd. I wouldn't have let her. We got into the little thing about the amendment. Now we're on October 4th. Talk about October 4th. You already talked about.
Sir, get to run the hearing. Do you understand that? Do you actually understand that?
I do when there's a judge that's running the hearing.
Okay, that's cool.
I just have to make sure this is all on the record because you're obviously. No, I have to state this, that you're not, that she's again trying to talk about something that we've already moved on from.
Well, apparently we haven't moved on.
You don't get to go in reverse. We'll be here for the next 2 weeks then.
Okay, I get to go in reverse vote. Cite me some case law on that one.
On what?
I don't get to go in reverse.
It's procedure, it's not case law.
Okay, cite me the procedure.
You want me to give me...
No, that's okay. Go ahead.
Don't play with me, sir, because I'll pull it out right now. I'll be on Westlaw while she's talking.
Cool. Go ahead, back to September. You want to elaborate on September 12th?
Just to close out what's stated in the petition, which is that the phone call ended with Mr. Myers.
But hold on, she already stated, sir, what was in there. She said she was going to go with what was in the petition.
Okay, I mean,
I'm about to read from the petition.
is there a reason? I'll let you do that.
So we're going in circles.
He ended the call by saying, one of two things is going to happen. Either you are going to help me or I am going to expose everyone.
Sounds really threatening.
And this is why we're here, folks. This is some of the harassment that Stacey Jane is alleging Lane made.
Sir,
It's right here.
I don't care what it is. Don't quit commenting on the testimony. You say you understand the rules.
I
You understand the law.
Do you?
Yes, sir, I do. And does that permit you to comment on the testimony?
No, it doesn't. I'm not allowed to do that, and I'm being rude and interrupting. I'm sorry. I'm trying to do my best to keep it under control.
All right, go ahead, Ms. Jane.
I believe that a reasonable person in my position receiving a phone call that ends with the statement, either you're going to help me or I'm going to expose everyone, would be alarmed, annoyed, and harassed. And in fact, I was alarmed, annoyed, and harassed by that phone call.
Okay.
On October 4th, I received another phone call from Lane Myers. I answered not knowing who it was, and when I said hello, he said, hey Stacey, I'm going to give you one chance to explain yourself before I file this lawsuit against you. Why did you call Judge Zips and get my wife fired from her job? I said, who is this? Lane said, you know exactly who this is. This is Lane Myers. I know what you did. I know you called Judge Myers and got my wife
Judge
fired
Zips.
from her job. I know why you called Judge Zips and got my wife fired from her job at federal court. I said that information is incorrect. This phone call is harassment. Do not call this number again. And I hung up. Lane sent me a series of text messages stating if it's not true, you would have made a statement for the record and not hung up, along with a link to Arizona's harassment statute. I have no contact with Mr. Wire.
You notice how she left out? Sir, she needs to read. If she's going to read from the paper, you can't skip words.
And I have not at any time communicated with anyone at federal court for employment. This call in combination with a call on the 12th, I think both calls would cause a reasonable person to be alarmed, annoyed, harassed. I in fact was alarmed, annoyed, and harassed, and I believe that the call on the 4th was demonstrating an increasing level of intimidation by Mr. Myers, at which point I filed for the injunction against harassment.
All right, do you have anything else you want there?
Not at this time.
All right,
She needs to present her exhibits.
do you have any exhibits you want to present?
She should have already given them to me before the hearing started also. By law. I turned mine in weeks ago.
I haven't received any
I haven't.
exhibits from Mr. Myers.
Of course, I turned them in digitals.
Usually we receive them this morning on the computer, and they were in the continued hearing, they were still on the digital computer, no one received notice.
Notice of what?
That they would be on the computer, so last hearing before it was continued, they were on the computer.
Right, yeah, like I turned them in before the last hearing.
It wasn't until the day of the hearing.
Right, okay. But all I'm saying is okay, so now she did her testimony, right? Now, does she have any evidence to support these allegations that she wants to turn in?
That,
That's what I'm saying. Before you move to me.
I asked the question.
Thank you.
Your Honor, I did submit a number of YouTube videos made by Mr. Myers, which included comments about me, but my understanding is that those would not be admissible today if the issue before the court is limited to the current.
That would be true.
So is it my turn? So talking to you, is that her saying she is not presenting a recording of either of these phone calls?
I'm not in possession of recording of.
Okay, well, so is it my turn now?
Yeah.
I do have a copy of the text message that Mr. Myers sent. I have copies of emails I've received from other people related to Lane Myers.
Not relevant.
Text message to you would be relevant.
No, that is. I'm talking about the emails. The text message is in my exhibits, is what I'm saying. The text message that she's talking about.
Is there anything that you want me to look at?
Again, Your Honor, I think that his conduct on YouTube and the conduct of.
YouTube is not mentioned in this petition?
Hey.
Petition?
Hey!
as well as his conduct in the courtroom
Remember
today.
that thing about not interrupting? Okay, go ahead.
It is my position that the YouTube videos and his conduct, in the emails I've received from people who watch him, and his conduct in the courtroom today are all relevant to the level of harassment I am experiencing because of Mr. Myers. At a minimum, I'd like to
When
admit.
did YouTube things occur?
Whoa. Unless she's gonna enter evidence, this is hearsay.
When hearsay is admissible, you know that.
But she's not moving to admit
She's
hearsay.
answering a question, right? When were they?
The first one that I'm aware of occurred on October 2nd, and there were additional videos as recently as last week.
And you did not include those in your petition
Uh,
on October 2nd?
I have not included any YouTube videos in my
I
petition.
believe Mr. Myers is correct as a matter of in the case that was the case that hearing limited to the matters that are actually presented within the petition. That's like 4 or 5 years ago in the case.
Then at this point, all I would have to admit would be the copies of the text messages.
You,
I do object.
without objection,
The text messages on October 12th, October 4th, right? Those are that's what I'm saying. It says that there's a text message on October 4th.
I'll check.
Okay.
There's one.
Thank you. Yep.
So I don't see a date on this, but I presume this is one you're referring to?
That's September. That's the one. That's the text message referred to in the petition, sir. I'm going to be entering the same thing, and it'll have the date and all that
This will
too.
be admitted into evidence.
Yep.
Without objection. All right, go ahead.
Me?
Yeah.
So, am I attacking her evidence now? Because I already did my opening statement. You know.
Testify.
All right. I already tested. No, it's my right. Not my opening statement. All right. So we're going to start by the plaintiff herself. Just said in open court on the record forever that I contacted her. We should admit my evidence first.
What is it you actually have?
I have the recording of the phone. I have my evidence is this recording right here. See how she says I called?
Okay.
And this that she called, and it's a digital copy of the text.
They're both calls or just one?
Both. And if that ain't working, I got this too.
Do you have any objection to the admission of the recordings?
No, Your Honor.
Okay.
I mean, they're the calls that got me an injunction.
She's not.
So now they're not going to be we're going to hear the whole call now, not the paraphrasing of it that fit her agenda.
Do you have something?
Yeah. So how do we? So should that's what I'm trying to say is like if you got my things, I want to play my thing and then use my evidence to counter her testimony.
Do you have that USB drive, Mr. Myers?
Yeah, right here.
It'll be displayed on the big screen there.
Do I move the mouse or you move it or what?
I'll move it here.
Okay. And she said that my behavior in court today should affect your ruling. Well, what about her buddy right here? That should affect the ruling too.
Is he a party?
He is. So let's go to, this is for the next case, all these lies. Let's see.
Sir.
Let's go to
Strike
perjury.
out whatever record exists.
All right, let's see.
Do you want me to scroll up or down?
The calls are under, go to perjury. See the file of perjury? Click on that. There you go. Stacy Jane, call 1, right here. Play that. This is the call on September 12th.
Hello, can I speak to Stacy Butler, please?
This is Stacy Jane. My former name is Stacy Butler.
All right, cool. Well, congratulations. I don't know if that's in reverse or going forward. You got a new name, but my name is Catherine Hendricks is my girlfriend, and we spoke by email a year or two ago, about 2 years ago. So you're the access to justice person, right?
I am, and I do remember that email. I'm actually on the other line on a work call. I just wasn't sure what this number was.
Oh, my bad. It's the listed number for you. Sorry.
Yeah, that's okay.
about for some stuff that's going on in Tucson right now.
Okay, could you just send me an email, actually? I'm in the car and on a work call.
Absolutely, absolutely, no worries, absolutely.
Do you have my email address?
Do you want me to use the same one? Let's see, this is Stacy Butler at Arizona.edu.
Yeah, it's actually Stacy J now, but Stacy Butler will forward to it.
Okay, so how do you spell the last one now?
STACYJANE.
Jane, okay. Alright, well,
At Arizona.edu.
and so I got arrested at the council meeting for booing. I know this is gonna probably something you're not gonna really wanna touch because these are probably a bunch of your friends, but my wife also went there too, so it's a long story, but I'm fighting the city of Tucson for booing during the city council. I'm charged with 3 charges, and so like this is access to justice stuff where like I'm doing it pro se. I could get a lawyer, but I want to show the whole community how the law works and our rights, and like it's a whole thing where like you guys work with literally the Pima County Prosecutor's Office. So I'm either gonna get help from you or I'm gonna expose the ironic hypocrisy that goes on down there. It's one or the other.
Okay, yeah, if you can send me an email, that's the best way to keep this on my radar.
All right.
Alright, thanks. Bye.
Again, this is one of the harassing phone calls Stacy Jane is alleging Lane made. Let us know in the comments if you think that's harassing.
Text that you referred to
Which one?
in that phone call, the one that you objected to?
The one we just listened to was this, the first one.
No, I know, but in that phone call, you referenced that you sent her a text 2 years before.
Email. That's the email that she referred to right there.
And that's the one you objected to.
That's the only contact I've ever had with that
Okay,
woman.
well, actually, since you actually brought it up yourself, that may give it some more relevance, so maybe we can.
Okay, cool, that'll even benefit me.
Okay.
I believe but
Right.
you can't use it for the injunction because it's outside 2 years.
And
It doesn't matter if you've contacted somebody 5 million times. There's people that get these against their wife that they've been in a relationship with
Sir?
25 years. It doesn't matter what happened.
I've actually done these things before.
So I hope you have done these before because.
Sir, could you stand someplace else?
Oh my bad. I thought you were asking me. So that was September.
Just asking if that was.
All right. So that was September 12th, and as we just heard in her testimony now on the record a few minutes ago, and in the call, she said that I called about access to justice, okay? And if you notice, when she referred to the second call, which we'll get to in a second, she indicated that during that call, she said this on the second call, not this call. Nobody just heard this, the whole world.
Wait, I'm confused.
I'm making a point here.
I know you're making a point, but I'm confused.
Right. I'm getting there. All right, so I'll start over with it, to be clear. So we just listened to that phone call.
Yes.
At no point did that person say, you're harassing me, or any of that. In fact, she said, let me know what's happening. Here's how you can get a hold of me. Keep me in touch. I'll see what I can do. Okay. In the next call that is on here, she testified in court and wrote on this paper, and we'll hear on the call where she said, this call is harassment, okay? Well, we can clearly hear that this woman knows how to say this is harassment and this is call me and I'll see what I can do to help you, okay? So I want to make a point right now. We just heard this call and multiple times in this phone call that she's using and calling this is harassment. She encouraged Mr. Myers to contact her again in regards to the access to justice issues that he called and started the phone call. You heard it. You heard the call. You heard her testimony. Now you heard the call where she left out key parts where she said either you're in her testimony on paper, which I believe could be getting close to perjury now, is that one of two things is going to happen.
I'm going to strike that axe.
I get what you're saying. All right. It's fair. That's fair. I'm not accusing her of it. I'm saying this is where we start getting off track. One of two things is going to happen. Either you're going to help me or you're going to expose everyone. But the call didn't say that. That's not what it said, did it? The call said, can you go back towards the end there? About right? Yeah.
Right there?
Yeah. I'm doing it pro se. I could get a lawyer, but I want to show the whole community how the law works and our rights, and like it's a whole thing where like you guys work with literally the Pima County Prosecutor's Office. So I'm either gonna it's one or the other. Thank you. So I said I'm gonna expose the ironic hypocrisy that goes on down there. I did not say either you're gonna help me. Oh, my bad. I did not say one of two things is going to happen. Either you're going to help me or I'm going to expose everyone. I said either you're going to help me or either if you can't help me, we can hear. I didn't put an ultimatum to this person. Down there. That's not related to a person.
This is testimony.
I get what you're saying. Right. So I'm saying that's not saying you need to do this, or this is going to happen to you, or this person. This is, I'm going to expose the hypocrisy down there. Okay, so we can see that her testimony on the paper to get the injunction is not clear and consistent with what was actually in the phone call, because the actual phone call, this is just a paraphrasing of it that I believe, if we took this as a straight transcript, word for word in a sense, this transcript, her transcription of the events into this little box, does not match up with the words that we would hear, for example, in a transcription word for word. I believe he changed some of the words in the petition right here, as the video just showed. I said I was exposed down there, as in the school and the relationships, social access to justice, all that. And she says it's harassment, but she also immediately admitted that it was for a legitimate reason as to justice. And during the call, she said, call me back, and you have a legitimate reason to contact me again, because I want to know what happens with this. At the end of that call, she did not say this is harassment or don't call me. Okay, so now moving on to the next one. So September 12th, that 4 hours later, my wife gets from her job as a law clerk for Judge Angie Martinez at the federal court. 4 hours later.
Is that relevant to this?
Absolutely. She's saying in this next one, right? She's saying that I had nothing to do with your wife getting fired. Okay, so now we're gonna get into it.
So why don't we get to the call first? I think you put the cart before the horse.
Well, I mean, I want to talk about her paper testimony before, so I want to bring up some points she made in her paper testimony.
Okay, go ahead.
She said she received a phone call not knowing who it was. Okay, I said I'm going to give you a chance to explain yourself about that, because before I...
Where are we at?
Right here.
Where are we talking about?
Right there.
September...
No, the top one. The first, the highest one. Right
October 4th.
Yes,
Okay,
yes, sir.
right.
Okay, so October 4th. Now, mind you, she attempted to introduce and to hear about my YouTube videos and stuff. However, what she fails to mention is on October 4th, I called her and said, as we'll hear, before I make accusations against you and put them on YouTube, I'm going to give you a chance to speak for yourself. That's called being a polite human, not just defaming her. So, okay, so now, on the legitimate purpose under Arizona, this harassment thing, my legitimate purpose on October 4th was to call her before I put because I'm a news reporter. I have a news company in the state of Arizona, and I'm a media outlet. So before I put a recording, before I put statements out accusing her of having something to do with it, I gave her a chance to speak for herself. I said, hey, I'm about to make these accusations against you. Do you want to speak for yourself first? Okay. She, as you can see, she immediately said, this is harassment. Do not call this number again. Okay. That was on 10-4. So at that moment, I thought, oh,
This is the other harassment Stacey Jane is alleging Lane made.
okay, well, since this was a legitimate purpose to call her, whether she was a public employee or not, because I'm calling to ask her this specific question. Now, if I called her 25 times a day saying, hey, it was you. No. One call. Did you have anything to do with this? You don't want me to call you? I won't call you again. Bye. Okay, that was on October 4th. So she says that I then text her the thing, because at that moment, the text, right? The text followed up the call, right? Because at the end of the day, as I said, judicial notice of adjudicated fact, this woman's employed by the state of Arizona, and not liking her name is a legitimate reason to call. I mean, you can't harass her, but people can call state employees and redress. They don't like what's happening.
You're arguing. Let's keep to the testimony of the facts first.
I feel you, because I do have case law too.
Well,
And so,
that'd be fine.
no, I know. So what this video is going to show is that she paraphrased it again, and all I did was communicate with her that she is a public employee, and therefore this one communication, because the injunction of harassment is designed is
Okay, don't argue the law yet.
a series of acts. Okay, so play it then. Play it.
Yeah.
October 4th. Play it. This is the call on October 4th, sir.
Hello?
Hey, Stacey, I wanted to give you a chance to explain yourself before I file this lawsuit against you. Why'd you call Judge Zips after our phone call?
I'm sorry, who is this?
This is Lane Myers. You know exactly what you did and who this is and why I'm calling. You called Judge Zips after you spoke and got my wife fired from her job.
That information is incorrect, and this phone call is harassment. Do not call my phone again.
It's not harassment. You're a public employee. That's the call, sir. So in that call, she states that, you know, I asked her who it was. So I clearly I told her why I was calling, who I was, the intention of my call, what I was doing, allowing her a chance to say something before I took action on what I believed to be the circumstances. Okay. I gave her an opportunity to say that wasn't me. But most importantly, even if we took this to the most extreme definition and said that call was harassing, which I don't think it is, and it's definitely, I'm going to showcase all why it wasn't. Even if it was, it's when she said don't contact her again, I never contacted her again. That's when the note saying, hey, this call is harassment. The next call would be a call of a series of acts. Not the one before that where you tell me call you again, and then when I call you again, you say this is harassment. You can't retroactively apply that. Yeah.
You got the call on September 12th. Well, first you had something 2 years ago. It was just,
That's irrelevant. But I get what you're saying. I get what you're saying. The call on September 12th.
You yourself brought it up. It's a point of reference.
No, it was in the call.
Yeah, it's a point of reference.
She asked how I got hurt.
Yeah.
I referenced that I'm the guy that I spoke to 2 years ago about
You say you got things.
Right.
Let me get through this. So September 12th, you have this call. We have the text.
About access to justice.
Right.
Legitimate.
September 4th, you call again.
No, October 4th. October 4th.
I'm sorry. That's my bad. October 4th, you believe something has happened.
Outside of court, or outside of this situation.
You believe
Right.
something has happened.
Right.
You call her to address that.
Yes. One time.
Then you send, when do you send the,
As soon as she hung up on me.
so she legally.
Yeah. Like she hung up on me and I sent her the statute saying, because you notice at the end of the call I said, you're a public employee, and I sent her the statute that,
I just wanted to.
the electronic harassment statute.
Okay. I got the time frame.
Okay. So that calls that she paraphrased as harassment when they're legitimate purposes. So now do I get to make my legal arguments?
Well, no.
Okay.
She gets to come back.
About,
You don't testify?
she gets to attack my evidence.
Yeah, well, she
Okay,
gets-
okay.
Perfect. That's about it.
Your Honor, given that Mr. Myers just testified that he had never mentioned anything about his wife being fired from federal court until he tried to verify that information with me on October 4th, I would move to admit his October 2nd YouTube video in which he accuses me of having his wife fired.
Irrelevant, not true. She doesn't have that. That's outside. She should have She should have put on the petition before she filed it.
Hey, stop for a second. You know, I tried to think something.
All right.
It doesn't help to have you yelling at me. Thank you.
She could have put it on here.
Help
Though.
to have you-
She could have put it on here if she had time. Why didn't she put through this?
But you just-
The second is before the
Let me
seventh.
think, sir. Oh, I appreciate you.
Your Honor, it's relevant to Mr. Myers' testimony today.
So what's the relevance?
He just testified that he called me on October 4th for a legitimate purpose, which was to verify whether I had anything to do with his wife being fired from federal court. And he testified that that was legitimate because he was verifying viewers.
It was only
video
6,000 at the time.
in which he
She helped me get the next
accused
3,000
me of having
with this.
Can you not interrupt her, please? It doesn't help.
It's growing. Hey, I bet you I got 10,000 by the end of this hearing.
Okay, that's wonderful. Go ahead. So what's the?
It's relevant to legitimate purpose for the October 4th call.
I don't need a legitimate purpose, sir. I was saying that she said that
I asked you not to interrupt. I'm going to let you talk.
Okay.
Keep interrupting me.
She testified that I called her about that.
Why are you going to ask me? I'm asking for her position.
But her positions are not legally cognizable.
Well, that's act of discrimination. We may disagree with it. At the moment, it's my determination. You'll get to make your own. Go ahead.
Your Honor, I move to strike the comment that my arguments before the court are not legally cognizable. So offense have been untrue.
Yeah, that's fine. So what's the relevance?
One of the elements of harassment is whether he has a legitimate purpose for his contacts. And he just testified that he did have a legitimate purpose on October 4th because he is some sort of journalist who goes to verify facts before he posts them in the public media. And he actually posted on October 2nd, before attempting to verify with me, he posted a video in which he accuses me of having his wife fired. I would like to admit that video into evidence because it undermines the legitimacy of his October 4th call to me.
It does not, because the IRS statute for electronic harassment, she's a state employee. The reason I said it on purpose, I made it very clear on the record, all this is being recorded and will be typed out for the appeal. I said, whether she was a public employee or not, that call would be a legitimate purpose. Any call to this woman is a legitimate purpose during business hours on her business line regarding her business functions at the University of Arizona. She's a state employee. The subsection for electronic harassment, which a social media post, which is section ARS 132916, use of an electronic communication to terrify. This section does not apply to constitutionally protected speech or activity or to any activity authorized by law. And the case law is very settled. In LaFaro v. Cahill, third-party contacts, her seeing my YouTube video does not represent a contact to her. It's a third-party thing. If she doesn't like what I'm saying in my YouTube video, don't watch.
Okay. You did post a YouTube video.
I plead the fifth. It's irrelevant.
It's not happening.
Of course it is. It's irrelevant. I'm not going to bring things outside the scope of this petition into this hearing like she is. You don't have the. Am I detained? Am I under arrest? Am I under investigation? No. She doesn't get to question things that are not on this petition, and you don't get to ask me about YouTube videos that are not contained in this petition. If they're not in this petition, and she had
Quit interrupting me.
interrupting you, you asked me a question.
I did. And you come on. I will accept your testimony that you posted a YouTube video. I'm not looking at YouTube video.
Of course, you need to look at it if you're going to.
You want me to look at it?
You're not allowed.
Well, you just told me I have to.
Is she introducing it as evidence?
I'm going to present the fact she did it.
Then provide me a copy of it right now. You can't introduce someone in evidence that I don't have a copy. You see how when she wanted to put the thing in, they had to stamp me.
Don't tell me what I can do in my court.
You can't admit evidence on hearsay.
You're missing her testimony. The fact that the YouTube video exists.
You just said you're admitting the YouTube video.
No, I didn't say that.
Oh, okay, that's why I was telling you to. Okay, so you're saying you're admitting testimony about her referring to a YouTube,
Yes,
but you're not allowing the YouTube video, right?
I accept it, and it's about.
Can you accept that she's stating that that video that she's referring to allegedly took place on October 2nd, and her petition was filed on October 7th, and she included an incident
we've already been through that.
from October 4th, so why didn't she put it on here when she could have put that on here? Why is she waiting till now to bring it up when it was?
Okay. You already won that point.
No, and that's why it's better to be quiet when you're winning. I get it.
All right, go ahead.
I just want to clarify that I understand we are a one-party recording state, but both of those calls were recorded and posted on YouTube without my permission. To the extent that Mr. Myers is somehow arguing that my demeanor at the start of the September 12th call doesn't seem to reflect a level of alarm, annoyance, or harassment. I am trained as part of my job to remain calm when dealing with self-represented litigants who are often agitated by the legal system. The call,
Mr. Myers, come on.
the call became.
These guys are all members. You're all members of the bar,
All right, you don't.
the Bar Association.
That's wonderful.
This is an embarrassment to lawyers across the country.
Okay, I will strike that. One.
You're letting this lady grovel on with nonsense.
All right, I'm going to strike that. You go ahead.
What I consider to be the most concerning, alarming, annoying, or harassing part of that September 12th call comes at the end. And I don't think I actually respond after he makes his comment at the end, something to the effect of, and I'm paraphrasing because I did not record the call, something to the effect of one of two things is going to happen.
Play it.
Help me.
I've heard it, I've got it.
The hypocrisy. I do think that comment is threatening. I think it is trying to incite me to take some sort of action, and threatening me with a consequence, or threatening perhaps the larger judiciary or legal system with a consequence if I don't help him.
Hearsay.
With respect to the phone call on October 4th, I just want to point out that he just threatened me with a lawsuit in that phone call.
That's not a threat.
Okay, do you need to interrupt all the testimony?
I do, because we have. It's like, are we moving towards a point here? She lied.
Okay, I'm going to strike that.
You think the tone of the October 4th call is much more aggressive?
The tone. We're not tone police. We're not tone police.
Okay.
These are not illegal cognizable arguments. You can't come in here and argue about somebody's tone when it's not backed in case law. There's no case law that says anybody's been convicted on their tone.
You're not being convicted.
I am.
Tone is actually very relevant.
It's not. Only in your feelings.
Don't you find it ironic? The only non-lawyer in the room is demanding to hear case law for this argument?
Not in case law.
Okay, cut it out, just listen to her, listen to you.
Tone police.
Cut it out.
We're taught the tone.
Okay, yeah, I heard you say that 3 times.
Don't get an injunction harassment based on the tone of a phone call.
5 times. You want to repeat it? Go ahead.
I experienced the tone to be more intimidating and aggressive than the prior call, which I think is relevant to whether a reasonable person in my position would be alarmed, annoyed, or harassed. I will reiterate that I do feel alarmed, annoyed, and harassed by Mr. Meyer's communications, and particularly his conduct in the courtroom today.
What does that got to do with this?
Just let it testify.
I also want to point out, based on Mr. Meyer's evidence that he just admitted, that I did ask in the October 4th call that he not contact me again, and then he immediately texted me at my cell phone number with additional contacts.
Okay, thank you. All right, Mr. Myers. Do you have any additional legal argument you might want to
Case law.
Whether I make it now or at the end of the hearing, Your Honor, I do want to ask that Mr. Myers be prohibited from posting today's court proceeding on YouTube.
That's never going to happen. Not only am I going to post it, but thousands. It's already being broadcast around the whole world right now live. Thank you. She's not going to hide. She's not going to. You said it was on me.
I did say that.
Oh, okay.
I'm almost there.
Oh, okay, my bad. Can I get a drink?
Sure.
Thank you.
Your Honor, while he's doing that, can I grab a pen?
Sure. What?
He's fucking recording.
What? He's recording?
Audio recording, yeah.
Did he ask permission under 122H? Didn't you just tell him not to do anything without your permission? He just can't follow the rules.
You said that everybody was recording.
You have to put in your own, every person put in their own notice.
Actually, they did not.
They did. Ask her.
3 of them put in notice.
That's the only people recording.
Can I say something, Your Honor?
No. All right, let's proceed. Mr. Your argument?
Is my turn?
Yeah.
Okay. Had to get some water. This shit's getting
Hey, watch your language.
stuff. My bad. So, an injunction for harassment, the standard is ARS 12-1809. The purpose of this section, harassment, is Section T, a series of acts. We've already got into this. Serves no legitimate purpose. Legitimate purpose is defined as what? She never said. Okay? So, we're going to define it right now. Okay? So, she is a public employee employed by the public sector in the state of Arizona, and you can type her name in now right now, Stacy Jane, on YouTube, or on Google, U of A, Stacy Jane, U of A. I'm going to do it right here in front of the whole court, Stacy Jane, U of A. And you can see, Your Honor, when you type in Stacy Jane on Google, this comes up right here. That's that woman right there, sitting right there. It shows her name, her email, her contact information, the room number, her program. Okay? So for me to call a public employee on a public website is a legitimate purpose, okay? Furthermore, it says that she's the innovation and access to justice type person. So I called, and that was, even if I had never met her in my life, even if I had never emailed her fucking 2 years ago, I got a little disability with that. 2 years ago, and then even if she was not an employee of the state, even if she worked for Walmart and I called her about her job, that's a legitimate purpose. The tone, well, guess what, plaintiff? My alarm, my feeling alarm didn't go off when I called. I didn't get my feelings are being heard alarm, knowing that my tone, so she was trained to deal with people, and she told me this guy who, the September 12th, the one, she's saying that she only acted that way because she was trained to deal with pro se litigants, but the course of the call, as we can all hear, she said, she talked to me about my issue, she told me to email her, gave me her email to use, told me to call her again. So why would somebody with professional training in dealing with pro se idiots and domestic terrorists who go around making YouTube videos?
I don't think she said anything about terrorism.
Oh, okay, my bad. I mean, her buddies did. I mean, I got it confused. When the U of A police, when she complained to them, Yeah. Okay. Well, so me calling her for a legitimate purpose on this, but even more importantly, all the purpose stuff, is not even anything to do with her employment as a state where there's even more protections to contact her. You can get an injunction for harassment for a legitimate purpose against a non-public individual. You cannot get a public individual when your calls are in the course of her duty. Nobody called her at home. Nobody showed up at her house. Nobody shared any information that isn't on Google being shared by her right now. If I can't share this, then she can't share this. And it's the same thing. It's nothing more than her feelings when we have Lafaro versus Cahill, which makes it very clear that I've never contacted, so we can agree, I contacted her electronically by phone, and I contacted her again electronically. I've never contacted her in person, and I've never directed anybody else to contact her in person. That falls under, for the purpose of this section, E, the ARS. You go to E where it says they review anything electronic harassment falls under the standard of, definition of harassment. When it's electronic, you use 1329.16. Okay, and that specifically carves out a section in the law because social media and YouTube's a new thing. They actually had to make a new harassment statute in the state of Arizona, this electronic one, because when the original one, there wasn't even computer, you know what I mean? It was so old, there wasn't social media, you couldn't post. And so now the legislator created a statute, updating it, involving these very same issues, and in that statute, they carved out protections so people can use their First Amendment protected activity to contact public employees for legitimate public employee businesses. Nobody called there and said anything outside the scope of, you work at the law school, you have these at the law school, you have relationship with these people down at the court. Nothing was, anything to do with her personal life, nothing to do with her home life, nothing to do with outside of work. And then when I called her and she's trying to say, I called, that was because I was doing a favor. I'm not required to call her. You can defame public officials. You can legally, you can legally defame Counterman. You don't even understand. There's so much case law. Counterman, Colorado, Getz versus Welch. I have Page Schwenk versus Hartford. There's so much case law that says that you can even, not only can you contact public officials, you can literally go on YouTube and defame public officials. The second call? Yeah. To ask her if she had anything to do with my wife being fired from her job, because I called her and a couple hours later. So she was the law clerk for Judge Zips for 13 years. Right. So somebody called within 2 to 3 hours of me calling Stacey Jane, somebody called Judge Zips and my wife got let go. So that's exactly what happened. That's exactly what happened. Now did she have anything to do with that? I don't know. And that's why she... Hey, I just said I don't know if she has anything to do with that, okay? But it did happen. The fact that I called her and 3 hours later her best friend got my wife, walked out, is it causal? I don't know. Is it, I don't know. But I'm saying that's why I called her. Hey, do you got anything to do with this? Because I'm about to file a lawsuit based on my hunch that as soon as I called you, you freaked out and called Judge Zips and then my wife. And so I... file a lawsuit based on a hunch? Of course. If she abused the process and got an unlawful injunction for harassment, that's abuse of civil process. That's an intentional tort. What do you mean?
You said you got fired when you called her.
Yes, about my wife, about my First Amendment retaliation for my wife getting fired, not a lawsuit against her, a lawsuit against... Oh, okay. Yeah, no, I'm saying... Okay. I'm saying before I file a lawsuit and I make allegations, before I go to federal court and file a federal lawsuit and put her name on it and say, you called and got my wife fired, I need you to, you know what I mean? Here's your chance to testify. You know what I mean? No, it wasn't a tort of abuse of process until she went and took these and got this injunction, I'm saying. So the case law in Cahill, Lafaro versus Cahill, a third party, conversations between alleged harasser and third parties do not meet statutory definition of harassment under statute authorizing injunction against harassment, even though alleged harassment victim may have overheard a segment of conversation. Alleged harassing act was not directed at alleged victim. That's Lafaro versus Cahill. So what I said on YouTube, unless I said, hi, this is for you, and I sent it to her, that is third party communication, okay? So that has nothing to do with this, okay? So her bonus testimony today that she tried to slip under there is that my conversation or my communication wasn't legitimate on the fourth because I had already said something on the second. Okay, so that doesn't mean that I can't say something on the second and follow up on the fourth and then make a bigger story about it. It doesn't, at no point, this injunction is not legally enforceable either because she asked for me to be stopped from accessing the public library. Just because she works at the U of A doesn't mean she can stop my access to the U of A Law Library. And I believe truly that's all this was to stop me from accessing the law library to fight the cases that I was using because the law library was a resource that I was using as a pro se defendant.
I don't understand.
Yeah, right here, look. See this right here?
I don't. Yeah, I said.
See that address? That's the law.
Okay.
That's the law school. You know about U of A Law School, the James Rogers building, the law building. That's
what you're talking about.
so that's public property. So she took away my right. This judge, she testified, and this judge took away my access to a traditional public forum. Excuse me, it's a designated public forum because they put hours on it. But either way, she took away my access to a public library based on these allegations. That's not acceptable either. There should have been more vetting of these circumstances. She didn't even play the video. So
She didn't have the video.
the recording. She paraphrased. Okay.
I believe she testified she didn't have a recording.
No, I know. I get it. So she should have known that I was going to come in here and potentially play it, because she says that I do this and stuff, right? Yes, I hold public officials accountable. I record my conversations so that they can't make false accusations and injunction for harassments and then get away with it. Because then I come to court and we play the real tape and we hear that I didn't harass her and we hear that I did have a legitimate purpose. And she even testified, the first one, I called about access to justice. So you can cross that off right there based on her testimony. The first words out of her mouth, he called it an access to justice issue. Her website right here on the U of A says innovate. Access, justice, call her, programs, she did this, she's a social justice warrior, she created this, she created that, she helps people in the community. So I called her to see if I could get some help. The second call, I asked her if she had anything to do with it, whether she's a public employee or not. But the caveat in all this, she's an employee of the state of Arizona. And all these emails she's talking about from other people, get used to it. It's part of the job. The calls that she's gonna get now from putting me through this, all part of the job. It's her fault. You can't stop me from making YouTube videos about public employees. I just went through this with her buddy who coordinated another injunction. Her co-worker at the law school, they tried to this coordinated attack on me that's going to fail miserably.
Lane feels like this is a coordinated attack on him, and I can see how he feels that way because all the people coming after him are our colleagues.
So because I could see her reading off another injunction that was issued against me in a different court. So she came in here and read off somebody else's injunction today.
That's beyond the scope.
No, she's beyond the scope. She's reading Judge Griffin's order back to you as a request to try to get you to put the same conditions he did, and it's not happening. I'm not taking him down.
Don't know what you're talking about. Go ahead.
So my legal arguments are based on LaFaro versus Cahill, okay? Mahar versus Acuna, Wood versus Brill, because in the context of injunction against harassment, a single incident is insufficient to support a finding of harassment, which requires a minimum of 2 incidents. She had already admitted September 12th was a legitimate purpose. So we're down to 1 incident. We're debating about 10:04 was the call on October 4th, meet the definition. Well, guess what? In the context of injunction for harassment, a single incident, October 4th, is insufficient to support a finding of harassment, which requires a minimum of 2 incidents. State statutes concerning orders of protection do not authorize their use to this is most important, sir, and I want you to make sure your bell tone's on. State statutes concerning orders of protection do not authorize their usage to discourage people from yelling or engaging in harassment of the type prescribed by statutory provision that governs injunctions against harassment, nor do they authorize the use of firearms restrictions, which we'll get to in the next case, nor do they authorize the use of firearms restrictions to provide incentives for positive behavior or to teach people a lesson about civilized conduct. You can't get an injunction on me because you didn't like my tone while I used First Amendment protected activity. You cannot do that.
I can ask you to quit yelling at me.
You can, you're right, sir, but I have a hearing problem that causes me to talk loud because I don't have...
Try to adjust for that.
I get it. I just want to make sure it's all on the record in case this...
It's all on the record.
So conversation, so the third party, right? And most importantly, in LaFaro versus KO, statute authorizing injunction harassment cannot be used to restrict protected speech. That's literally the law. The law says you cannot use an injunction to chill protected speech. That's what she did. She doesn't want me to talk about what's going on, and she came in here and got this injunction.
Anything else to do that? I mean,
Oh, okay, I see what you're saying for the case law. So then we have the threatening definition of ARS 13202. I did not threaten to cause injury. Now then, she says that she felt threatened. All I did was say I was going to expose people, or she felt threatened. I said a lawsuit. She's a lawyer. Lawsuits, you know what I'm saying? So, and then when we get out of the state, because I just given you a bunch of state law cases, and we move into the Supreme Court. There's the Counterman case in June of 2023. Are you familiar with that?
I'm familiar with it, basic law.
Okay, so Counterman said this guy who is not Billy Counterman sent hundreds of Facebook messages to a local singer and musician, not even a public official. The two had never met, and CW did not respond. In fact, she tried repeatedly to block him, but each time Counterman created a new Facebook and resumed contacting.
I've got the point.
Well, then you should show that the state must prove in cases that the defendant had some subjective understanding, threatening nature, but the First Amendment requires no more showing. The First Amendment does not allow restrictions for you know what I mean? You get it? Because then in Cafaro versus Lafaro versus Cahill, but I need to get this last little thing on the record, and I'll be done. This last little quote. Okay. All right here, because it's about the type of right, and the speech. All right, because the point of this is. Sorry, I usually have this shit out right here.
Watch the language.
Stuff. Okay. Both parties. So the point is we can use obnoxious, even if I called in was obnoxious. The court noted the difficulty of adjusting a prohibition on all uninvited approaches of persons, regardless of how peaceful the contact may be, without burdening more speech than necessary to prevent intimidation and to ensure access to the court then held, absent evidence that the party's speech is independently prescribable, i.e. fighting words or threat, or so infused with violence as to be indistinguishable from a threat of physical harm, such provision cannot stand, okay? So you cannot avoid this case law, okay, because the trial court, you cannot, you could be found, just because it could be found to be annoying by a reasonable person. No, we reject the breathtaking proposition that courts may control speech to the imposition of some duty of fairness. The remedy for unfair speech is more speech, not silence of the speaker. Therefore, in addition to the factual insufficiencies of the petition, they vacated the injunction because the use of 12-1809 in this case impermissibly limited Cahill's right to freedom of speech. So to construe this in harmony with free speech, do you understand that you cannot say that, literally, you cannot say that speech just because you don't like it or you found it offensive.
Mr. Myers, I got the point.
I hope you do, because I hope you do. We're going to see in a second if you got the point.
Thank you, Ray. Let's go. Anything else?
Your Honor, I believe Mr. Myers has now opened the door to evidence related to when he has come to the law school in violation of the protective order, which has happened twice.
Well,
What are you talking about? I've never been to the law school except the day since before this injunction was issued. I have not been there since this injunction was issued. She's trying.
Hey! Let me talk to her first.
She needs a bar complaint. Are you going to put a bar complaint on her?
Are you going to be quiet for a moment?
Yeah, I'll make sure you put a bar complaint on her.
You can make sure I do anything you want.
Commission of Judicial Conduct, too.
What's the issue? He did not testify that he went to law school. He said it prevented him from going to law school.
Exactly. She's trying to.
It didn't, though. It didn't.
Okay, well, that's
separate from law school.
And that's a matter for criminal.
She just stated on the record, sir. Now we need to introduce this onto the record because now I'm going to get her for perjury. No, testify. She needs it. You cannot just let her make her up. You need to formulate the record, sir.
I will strike the testimony.
Thank you.
I mean, if you have a complaint, you take it.
If she thinks I came to the law school, she's got bigger problems than this injunction because she's going to get hit with a giant lawsuit. You cannot lie in court.
Hey, cut it out.
She just lied in court.
Strike everything that you said connection with that. Did you have anything else you want to say in terms of legal argument?
I believe that the mix of testimony and legal argument Mr. Lane just made also opened the door to evidence related to communications I've received from other people and communications he's posted on YouTube.
All right, I'm going to deny that request.
Okay.
On the record.
In closing, Your Honor, I would just say that I in terms of the course of my duty, I am a University of Arizona law professor. My research focuses on improving access to the civil legal system for people who don't have lawyers. I don't think that my role as the Director of Innovation for Justice means that people have permission to call me with threats of lawsuits, threats of...
Objection, no threats were made. There's no testimony of threats in the position. There is not the word threat anywhere in this petition. This is the same bullshit they pulled over at Griffin's the other day. Oh, they got threats, they were gonna rape me and all this shit, but they don't got the... Come on, man.
Quick, no. You
Don't get to allow her to lie. She's lying. She's lying, sir.
You're gonna cut it out?
Yeah, she's
I
lying.
don't care if she's lying at the moment. You need to just restrain yourself. Quit interrupting people. You get the chance to talk. When you get the chance, give other people the right to talk. Is it that hard? Go ahead.
Mr. Myers admitted his own evidence of the recordings, and in those recordings you will hear him both threaten me that if I don't do something to help him, he is going to expose some sort of hypocrisy, paraphrasing, and that if he's giving me one chance to respond before he filed a lawsuit against me, both of those. He ignored my request to stop being contacted by texting me after I asked him to contact me. He posted false statements about me to thousands of people on YouTube and recorded conversations with me without my knowledge or permission and posted those online as well. For all of these reasons, Your Honor, I would ask that you please endorse the current petition for injunction or the current order prohibiting harassment, at least while I file and litigate an amended petition for harassment to include all the conduct that Mr. Myers has engaged in since October 14th.
Thank you. Have a seat, Mr. Myers.
She just said the word threat, though, and it's not even on her petition. Where in these two statements that she used, she said, Lane called my cell phone, I answered. There's not the word threat in here. She did not say that he threatened me, anything, one thing. Nowhere in the second one did she say, did he threaten me? I felt threatened. Nothing about threatening until today at the last second. I'm surprised she didn't roll out the fake tears.
Strike your statements. I've listened to testimony, listened to the exhibits, trying to separate the wheat from the chaff, and there's a lot of chaff.
I don't want to contact her,
I said I'm trying to separate the wheat.
but I need to go to the law library.
Why are you interrupting me when I make a decision?
Because this is all a waste of all our time.
You waste lots of it.
No, I'm gonna be handsomely rewarded
Okay. Keep it to yourself.
for false accusations.
Sir,
I get it.
try to control it for a moment.
I'm gonna sit here and read Stacey Jane's website on Google.
You can read whatever you want yourself. We know the status of law in conjunction with harassment requires at least a series of acts, as Mr. Myers referred from the Lafarge case, the least acts that an ordinary and reasonable person would feel disturbed by. That's their no legitimate purpose. Looking at the testimony, Ms. Jane, reluctantly, I guess, but I find that, I certainly can find that the October 4th call may have constituted an act of harassment. The approach, given the context, I certainly agree that may be the case. Having listened to the October 12th call,
September 12th.
Should be September 12th call on a couple of occasions. Even listening to the tone and listening to the subtext, I just cannot find that constitutes an act of harassment. It may be that the other acts that you talked about that were not included within your petition may in fact constitute acts of harassment, but the law is clear, and it's got to be done before the hearing, that if you want to amend to include other acts, you could do that, but that was not done. Because of that, I'm going to have to dismiss this order. I guess somewhat reluctantly, because obviously...
Don't say that, sir, on the record. You can't say reluctantly. You sound like you're lawyering for her.
I can say I am reluctant, but I'm going to dismiss the matter.
That's prejudicial to me, though.
Okay.
Saying reluctant. I get it, though. Thank you, sir. Appreciate it. I'll be...
Quit interrupting me.
I know. I
know you know that, but you continue to do it.
I don't even know how to be quiet when I'm winning.
The judge ruled in Lane's favor. Injunction is no more.
But it's not over. because Lane has another harassment injunction hearing in 5 minutes. It's for her. She's a witness in the O'Reilly's case.
That's going to be our next video. Make sure to like and subscribe to Lane's channel and to our channel.
If you made it all the way to the end, thank you so much for watching, and we'll catch you in the next video.